The Honourable Nanaia Mahuta.
Mr Chair, following on from the sound contribution of my colleague Ruth Dyson, I wanted to make a comment on a number of matters that have been raised in the House, but more importantly ask the Minister to clarify on what evidence has she received to determine that by delegating the authority or giving the Chief Executive power to delegate care and protection responsibilities, that in itself is a sound decision. Because if, for example, and I heard previous contributions, the Minister is basing that on agreements with iwi, there would be evidence built into the MOUs that have been secured over the last 2 years, where iwi have been giving feedback on the way in which better responses to childcare and protection could happen. So I want to comment on the report that she recently received with regards to mokopuna order and some of the reflections, let's say observations that they've experienced in trying to make a care and protection system work well within an iwi context. And there are challenges. There are a number of challenges. The Minister has been briefed on it, and I know that she has been aware of the various aspects of the process by which Waikato Tainui responded to the 87-odd cases that they dealt with within their contracted period to try and ensure that, one, mokopuna were able to go back into whānau, two, that the process worked better for those who were in the care of these mokopuna, and three, to better coordinate the discussion with child, youth and family whose processes weren't as accessible to whānau as they could have been. And in working through the process, just the amount of effort that the iwi went into ensuring that in identifying and aligning child, youth and family expectations of whānau who were able to be carers and the kaitiaki that were selected, there was quite a bit of intensive work to try and ensure the right whānau were being picked. And by right I mean whānau were being given enough information about their responsibilities, but also how to navigate the system in a way that was going to ultimately be beneficial for the mokopuna. A number of hui were held, wānanga, if you like, and they made some, I think, useful observations to the Minister. Were it to be adopted, there were things that needed to be absolutely crucial. The other part of it were the iwi support advisors who ultimately were charged with working with kaitiaki and mokopuna to better ensure that whānau plans were being developed. Now, my understanding of the amount of intensive effort that went into this, very little of that, I guess, engagement required a specific set of social work or it was more around case management. Now, if that is the case, and that case management or navigator assistance was at the core of the iwi support advisors and being able to develop whānau plans for mokopuna that were going to be not only be implemented, but implemented to the extent that you wouldn't see these mokopuna going in the revolving system of state care, there were a range of issues that were identified in making this work. Minister, I know that this was, I think my concern that I'm raising right now is that this, at its initial stage, was evaluated, this whole process. There were some insights gained. Obviously, the extent of wraparound services was a lot more envisaged than was thought at the beginning. So it was a design phase that they went through. Once they presented the evidence, Minister, it would be, I think, only prudent to explain to the House again what justification to delegate state care has been received, because from the information I've received, there is still a lot more work to do within iwi settings in order to have absolute confidence that the care of mokopuna is at the heart of any decision-making process, The oversight of the Chief Executive of Child, Youth and Family remains a core oversight to ensure, Mr Chair,
The Honourable
the oversight, the oversight of the Chief Executive remains key to ensuring that children aren't in a revolving system of state care, but more importantly, and I think this is the insight from the iwi experience, a greater emphasis on the role of whānau, being responsible within the whole process. And I am aware that the Minister, the evaluations were made. There must be further evidence beyond the case that I'm citing, whereby you're making the decision to delegate, that the Chief Executive can delegate power, but on the basis on the report of what I've seen, it's too early yet. It's too early yet. And I would hate for iwi to be used as the gold star standard of the reason why such a provision exists when they even observe it's at a very early stage. And quite frankly, our children are far too important to gamble on provisions like this that don't give absolute confidence. So I'm asking the Minister to take a call, identify the range of evidence that's been provided to her to give her confidence that the Chief Executive should be given powers to delegate to another entity the care and protection responsibilities. And if that evidence is based on iwi examples, I do think that needs clarification, because I know that there is some nervousness still that remains with some of the iwi providers about ensuring they have got the best system possible before everything gets delegated to iwi. In saying that, Waikato Tainui have been very proactive in wanting to work alongside child, youth and family. They have observed that the processes are clunky and don't work in the favour of informing whānau clearly of the court process, the family group conference process and its consequent impacts on decision making. They do favour, from the research that I've seen, from the evaluation that I've seen, they do favour monitored implementation of whānau plans for the successful placement of mokopuna. They absolutely favour that as a process. They raised with you, Minister, concerns of any prospect to change Section 5C2 of the Principal Act. You may wish to take a call, even though because you've forecast, Minister, future changes to the legislation. And it would be, beyond Waikato Tainui, interesting to know whether there was a consistency of evaluation feedback, again, that gives confidence around the models being embarked on within iwi to retain children within whānau kin group care, but also to monitor the prevention of children being kind of into the care cycle, so that they're into long-term care placement. Kia ora tātou.
Members, I propose to group some of the clauses for votes to leave the opportunity for people to vote the way that they want to, where there is division, but not to take all night putting the votes. So the question is that clauses 1 to 3 stand part. Those who are of that opinion will say aye. The contrary, no. No. The ayes have it. The question now is that clause 4, that Jacinda Ardern's amendment set out on SOP number 248 stand part. Those who are of that opinion will say aye. The contrary opinion will say no. The ayes have it. A party vote is called for. The clerk will conduct a party vote.
New Zealand National.
59 opposed.
New Zealand Labour.
31 votes in favour.
Green Party.
13 votes in favour.
New Zealand First.
12 votes opposed.
Maori Party.
2 opposed.
Act New Zealand.
1 opposed.
United Future.
1 opposed.
So we're doing this.
The ayes are 43, the noes are 75, the noes have it. The question then is that clause 4 stand part. Those that are of that opinion will say aye. Contrary opinion will say no. The ayes have it. The question now is that clause 5 stand part. Those that are of that opinion will say aye. Contrary opinion will say no. The ayes have it. A party vote is called for. The clerk will conduct a party vote.
New Zealand National.
59 in favour.
New Zealand Labour.
31 votes in favour.
Green Party.
13 votes opposed.
New Zealand First.
12 votes in favour.
Maori Party.
2 in favour.
ACT New Zealand.
1 in favour.
United Future.
1 in favour.
The ayes are 106, the noes are 13. The ayes have it. The question now is that Jacinda Ardern's amendment set out on SOP number 248 be agreed to. It's part of clause 6. Those of that opinion will say aye. The contrary opinion will say no. Ayes have it. A party vote is called for. The clerk will conduct a party vote.
New Zealand National.
59 opposed.
New Zealand Labour.
31 in favour.
Green Party.
13 in favour.
New Zealand First.
12 votes opposed.
Maori Party.
2 opposed.
ACT New Zealand.
1 opposed.
United Future.
1 opposed.
The ayes are 44, the noes are 75. The amendment is not agreed to. The question is that clause 6 stand part. Those that are of that opinion will say aye. Contrary opinion will say no. The ayes have it. A party vote is called for. Clerk will conduct a party vote.
New Zealand National.
59 in favour.
New Zealand Labour.
31 in favour.
Green Party.
13 opposed.
New Zealand First.
12 votes in favour.
Maori Party.
2 in favour.
ACT New
1
Zealand.
in favour.
United Future.
1 in favour.
The ayes are 106, the noes are 13. Clause 6 will stand part. The question now is that clauses 7 to 11 and schedules 1 and 2 stand part. 1, 2 and 3 stand part. Those that are of that opinion will say aye. The contrary opinion will say no. The ayes have it. Party vote is called for. The clerk will conduct a party vote.
New Zealand National.
59 in favour.
New Zealand Labour.
31 opposed.
Green Party.
13 opposed.
New Zealand First.
12 votes in favour.
Maori Party.
2 in favour.
ACT New
1
Zealand.
in favour.
United
1
Future.
in favour.
We voted on your SOP.
Oh, sorry.
It's a deletion, so to vote against clause 7 standing.
Okay, I apologise. I have made an error in my grouping of the clauses. Jacinda Ardern, so I'm going to go back and put Jacinda Ardern's amendment, the effect of which is to delete clause 7. Those are in favour of that amendment say aye. Aye. The contrary opinion say no. The noes have it. Party votes called for. The clerk will conduct a party vote. I apologise.
New Zealand National.
59 opposed.
New Zealand Labour.
31 in favour.
Green Party.
13 in favour.
New Zealand First.
12 votes opposed.
Maori Party.
2 opposed.
ACT New Zealand.
1 opposed.
United
1
Future.
opposed.
Right. The ayes are 44, the noes are 75. The amendment is not agreed to. We'll then go as we were. The questions are that clauses 7 to 11 and schedules 1, 2 and 3 stand part. Those who are of that opinion will say aye. The contrary opinion will say no. No. The ayes have it. A party vote is called for. The clerk will conduct a party vote.
New Zealand National.
59 in favour.
New Zealand Labour.
31 opposed.
Green Party.
13 opposed.
New Zealand First.
12 votes in favour.
Maori Party.
2 in favour.
ACT New
1
Zealand.
in favour.
United
1
Future.
in favour.
The ayes are 75, the noes are 44. I will report this bill without amendment.
The House is resumed. Mr Chairman.
Mr Speaker, the committee has considered the Children, Young Person and Their Families Advocacy, Workforce and Age Settings Amendment Bill and reports it without amendment. Mr Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. To the contrary, no. The ayes have it. The bill is set down for third reading next sitting day. A point of order, Jami-Lee Ross.
Mr Speaker, I seek leave for the House to suspend for the dinner break slightly early.
Leave is sought for that purpose. Is there any objection? There is no objection, and then I will resume the chair at 7:30.